You know, this is one of my favorite things to do, to read judgments from judges in this country. Enra, ena me de story bremo say Enrechi courts etenase. Emma Nana Agradaa 15 years ayama ne se won konkoda imfiase no. Court say wasesa no e de aba 1 year. Na me can say, well, that's quite interesting. We need to read the court documents and get to understand why the judge took that decision. Now, me catch them say, obi a person me read the court documents biano in the comment box throw one. Into no more throw one no mehu. Into no that is a confirmation. Say mo person me read the court documents. So we are going to go into the documents. What you see, and then first time or have me share subscribe and click the notification bell on so. Oyane sa latest news bi aba won sa ebeka na meguswa kai mo say wo fasi bi wo babi na obetron of deka mesre school ba kwa metumi recommend ama Sanctuary College onim say me recommendations there enye fedi agro Sanctuary College na ombekre akwala na de ama na passe ama weni age oye nurse ni opese okoko practice e wa brochi a eya na yema motro exams bi a yefene out Mesre School Way Sanctuary College. Frewomo 053-7730-272. Na wankasa beba bedi adanse. Mesanso kaimo se opeu umpeu afi ubediye afi ubenye sika. Ghana omanya yetimu afi wose wo invest wo oman ni mu. Me recommend book na eda screen no so no. Ye friend the Ghanaian investor. Ebetre bebi a wose wodi usika to. Na dachi usika no aso abapa ama. So upe book we bi ato a hard copy no obetumi nya bi wo Amazon. Oko Amazon now type the Ghanaian investor, you are going to get it. You be shape ya ba bia wo bia all over the world. Now so upe book no ewo WhatsApp so as PDF and a tree video and I say English video and 100 cedis per. Number ni 055 807 4986 055 807-4986 or WhatsApp number na ubenya. Mesrao comment box ni mu no. Second comment na wo no o click so a obetumi nya book no e wo screen so sorry o phone so. Screen so icons be atiase. Just say ya in such a way say book no maybe a opese onya book ni bia no e easy. Inti wangasa send ya open no we nya ne sa amaye. Now yan consem ni mu. I say in the Superior Court of Judicature and in the High Court of Justice, Amasaman, Accra, in the Greater Accra region, held before His Lordship Justice Solomon Oponchu Messi, sitting on Thursday, 5th day of February 2026. Now, Osha appeal, and according to appellant, no, Patricia Asiedua versus the Republic. So let's go into the case. 45 pages. Obviously, I can't read all the 45 pages for you, but let's go into the case and then the relevant side. No, making country. I'll say on 5th July 2025, the appellant hearing was convicted by the Circuit Court Accra on account of charlatanic advertisements in newspapers contrary to sections 137 of the Criminal and Other Offences Act 1960. The appellant was also convicted of 2 counts of defrauding by false pretenses, contrary to section 1311 of the same Criminal and Other Offences Act 1960, Act 29, and she was subsequently and consequently sentenced to a fine of 25 penalty units or in default 30 days imprisonment on count 1 and 15 years imprisonment in hard labor, 15 years in hard labor on counts 2 and 3, with all sentences to run concurrently. That is to say, the appellant was to serve 15 years in hard labor in all. So basically, Osha, we any the brief of a year Agradaa, the case won conquer 15 years hard labor and insensem. Also, following the conviction and sentence, the appellant immediately, that is within 2 days after the conviction and sentence, launched the present appeal against both her conviction and conviction as well as the sentences. In the sentences na yedema Agradaa no 2 days after your man the sentences na no and na o appeal Into Osha appeal no, it has been going on for some time. Afiansa ruling aba. Into Obi Ebe ne say oh Agradaa ye sorry ya na assembly they call back to court ye di ruling aba ne dabi. 2 days exactly after ruling ne ba no Osha say or call appeal. What you say? It was said the grounds of appeal were stated as follows. I said the conviction and sentence should be set aside as the judgment is unreasonable and cannot be supported by the evidence on record. 2. The whole trial is wrongful in law. Particulars of error of law. A. The trial judge denied the petitioner a fair trial by calling upon her to prove her innocence when the prosecution had led no or sufficient evidence contrary to Article 19.2 of the 1992 Constitution. Inti Agradaa ne judges no appeal na womo ye no. One, asemo no more can say ruling na judge no amano yembongu because sabe nyansa enim evidence be anywhere say judge no 15 years no dia ma Agradaa no Agradaa esefata say odi 15 years dabi. Osi 2. Osi trial ni na eye wrong. The course ni na eye wrong. Judge no deny Agradaa a fair trial. Usha se ni a judge ni di case na asa Agradaa nsem de ompeso betie kra. Na evidence no enye sufficient enough say wo mo be 15 years ah. Say be 15 years enye fe di agro. At least anka wo say wonya evidence ah so but evidence a judge no edema 15 years no. Say be enso sa this is what Agradaa's lawyer claims. Right? Intino went on to say the sentence of 15 years imprisonment in hard labor is harsh and excessive, taking into consideration the circumstances of the case, exactly what I've said. Or say additional grounds of appeal to be filed upon the receipt of the judgment. And it went on and it went on. Now, let's go to judge no the ruling. The entire judge no omasa ruling. But before that, no judge no there is a preliminary procedural issues. Inti judge no raise say procedure no kra no issues on ho. And then den or say I have thoroughly examined the ROE and I must state in the first place that I did not seem to understand what the main grounds of appeal, particularly those that touched on the conviction were. And I say this because the appellant appeared to have combined her grounds of appeal, particularly ground 1, with the reliefs she is seeking from the court. Again, ground 2, which sought to attack the conviction of the appellant in the court before stated that the said court committed an error of law and counsel stated the particulars of said error of law. But it appeared to me that per the so-called particulars of the error of law, learned counsel for the appellant was apparently not stating any errors of law, apparently committed by the court below, but he only made factual statements such as why the appellant was called upon to open her defense. Counsel also threw in accusations of bias against Honorable Trial Circuit Judge and somehow concluded that the fundamental human and constitutional rights of the appellant were breached by those perceived acts of bias by the judge against the appellant, and on that basis, learned counsel for the appellant concluded that the court below fell into errors of law. Reference is made here to the particulars of errors as stated in in paragraph 2. Inti judge no kra no utien semo na judge ne kan na say judge no sha se o ka seti Agradaa ne lawyer no. Semo a wo ka say judge no waye error ne we no. Nkwa semo de aba betu menim no. Untre mu say waye error bia. O evidence a wo de aba na ntre say judge no waye error bia. So that is how the judge started by giving the judgment. I say again, counsel for the appellant used petitioner and accused interchangeably with reference to the appellant. Whereas these errors were not very material or grave, they demonstrated some level of unpreparedness on the part of lawyers for the appellant in filing the appeal. Hey, that is Agradaa ne lawyer ne kra no. Sebe, you see, case now or the buyer no. One say accused petitioner accused in law terms no, in court terms, an accused person is different from a petitioner. Yeka so be a petitioner, trese nipa kono no de asem na yeden aba. Yeka so be accused da nipa kono de asem na to ne so. Inti judge na asem a wo kan say Agradaa lawyer kra no. Ne nkrata wo de ba court no. why mistake or interchange accused any petitioner not just say judge Agradaa ne lawyer ne kra no one prepare answer wo back court nti wo hwa judge in the judgment na ekọ etia Agradaa ne lawyer no ati o say o enye mistake bi ye grave enye mistake bi ye kese sa but we trace judge Agradaa lawyer no one prepare. I say the settled principle of law is that in criminal appeals, when an appellant files a ground of appeal that states that his conviction and or sentence were not supported by the evidence on record, as in this case, then he is inviting the appellate court to thoroughly examine the ROA, make an appraisal of same to come to the conclusion as to whether the conviction / sentence were indeed supported or not supported by the evidence led at the trial. There is a chain of authorities to support this legal proposition. See, for example, and then the judge goes on. Now, I want to go to the most important part. See, again, the settled principle of practice is that this omnibus clause is, in criminal appeals is generally stated as the evidence led at the trial does not support the conviction of the appellant. In a case under review, ground 1 of appeal was not stated exactly in those terms. And so here, I say, judge no shall see a crown, and I say, or the Agradaa a lawyer no ako school, I know what train idea. And the judge was quoting, in the judge no try Agradaa lawyer no, and some of the by the mistakes a womb. I say, now, it goes on to say, discussions of the grounds of appeal. I say, it is obvious that the onus of proving all the grounds of appeal on the appellant. I start off by discussing ground 1 of the appeal, which was formulated. Thus, ground 1, the conviction and sentence should be set aside, as the judgment is unreasonable and cannot be supported by the evidence on record. As stated earlier, by this ground of appeal, the appellant was inviting this court to rehear the case by closely examining the ROE in order to determine whether the judgment is unreasonable and it is not supported by the ROE. So the question then is, what were the charges that were brought against the appellant, and what was the prosecution required to prove against the appellant? And yet again, at the end of the trial, was the prosecution able to prove its case against the appellant beyond reasonable doubt? The judge may break it down. Ebisa questions. Say, what shall Agradaa nsemu a wamudi aba? Was it first? Judge ne nsemu a wama isa Agradaa nkonko demu 15 years no sebe nyanse enim. Unreasonable. Now, it cannot be supported by evidence. In the judge, the question I will be saying, say, okay. So what the Saba appeals court need now per se, yes, and so teen same nibium. Because I walk say prosecution or more evidence and strong enough, say, you bet you Agradaa to man, you be massa judgment media. O per se me appeals court no, and appeals judge no. O per se me sanso tena assembly subium. A sanso tiena me who say indeed. Assem no evidence no enye strong enough and this is what the judge is saying. The judge didn't be questions. Say at this point, what was brought against the appellant and what was the prosecution required to prove? In the prosecution, no issues ben no murezi etia Agradaa. Evidence ben a prosecution no edigina wa wo mo tre say issues are ye rezi etia Agradaa no indeed. Any about in the judge will say and yet again at the end of the trial was the prosecution able to prove in the judge bisa say at the end of the trial no prosecution need to me prove it say indeed the entire was Agradaa ye den 15 years no any ana the judge no continues to say appellant beyond reasonable doubt or say was the prosecution able to prove its case against the appellant beyond reasonable doubt? I said the first count against the appellant was charlatanic advertisements in newspapers contrary to section 1371 of the Criminal and Other Offences Act 1960, Act 29. Into the first charge I did Agradaa, you can say charlatanic. Charlatanic, you can't say what you hey. Munim send Agradaa or yen nyama. Into Sanyama nitiaga nambra. What you say? Charlatanic. Oh, nyamia you say, and yamima yes, sa adverts no ne. What you say? Charlatanic mean nim ni tree, but basically that's what it means. Say senya na Agradaa wo ye ne nyama kasa ye advert wo TV so ni we no etia Ghana mra. I say the section provides as follows: charlatanic advertisements in newspapers is the publication in a journal or a newspaper of an advertisement or a notice relating to fortune telling, palmistry, astrology, or the use of any subtle craft, means, or device by which it is sought to deceive or impose on a member of the public, or which is likely to deceive or impose on a member of public to receive some benefits through illegal means. The judge need to say charge na ye de abo Agradaa charlatanic advertisement no. And the Ghana mra no, what is charlatanic advertisement? Inti osofo bi eba begina TV so no wo twa ntro say wo de bedi usika eno no. Eh ene na kamra ye adwuma wo Ghana pa na ka ye be cha asofo bebre o. Enye osofo pe obi ba begina say o media mitumi hu nsem ehu wo daache. Media mitumi hu bibi ehu wo daache. No oba begina ono ka no de di usika na ye ntro ana wo o de okoko run ntro mu a ye be chi na tum. That is what the judge is saying. And this is according to Ghana, your constitution, as the judge is reading. This is quite interesting. In the judge need to ask, I will say, the prosecution, in order to succeed, was required to show that there was a publication in the newspapers or journals, or that a notice was given through some other medium, such as radio, television, or social media, which sought to deceive the public or members of the public into believing that they would be receiving some benefit from the person making the advertisement. Were they to respond to same, and that the person making such publication / advertisement knew that it was false, but he did it with the sole purpose to deceive any such person who would respond to such a publication / advertisement. In the judge now say, in order for Agradaa to be convicted, say ye bet no e was same way so no. E was a prosecution need to me show evidence of Agradaa video bi a e bia wo yes advert no. Na was a prosecution no kra no etumi prove say indeed Agradaa de na wo ka no wonim say ye ntro e na wo de dada nkrofo. E was a prosecution prove sanyama ni na. I say in the instant case, the prosecution tendered in evidence 2 videos, namely Exhibit B, which were later transcribed to become Exhibit C and C1 and C2, by which the appellant invited members of the general public to an all-night church service the appellant was going to organize on 7th October 2022. In the judge say yes, evidence wo Agradaa video wo ka chen grofo so mumbra ne all night. Na date no na 7th October 2022. Also in the said video, the appellant was seen and heard saying that she, Reverend Dr. Mama Pat, was going to organize an all-night church service on October 7, 2022 at her church, and she would share 1 billion among possible attendees, particularly the financially needy at the said service, so that they can get some money to do something meaningful for themselves. And indeed, the appellant had packed bundles of money suspected to be Ghana cedis on a table behind her, which money she represented that she was going to give away during the all-night service. And this was confirmed by almost all the witnesses the prosecution called. In particular, PW1, PW2, into no video, no judge, no video, name say indeed, or no judge knew who Agradaa ni video walk at and Crawford say, well, betcha 1 billion, no mumbra, sorry, no mumbeji can be found conco ye juma. Witnesses eba betre say indeed Agradaa has answered no. Or say the burden on the prosecution as far as a charlatanic advertisement was concerned did not stop at just showing the publication about the all-night church service, but the prosecution was further required to show that some people bought into the advertisement and were subsequently and consequently lured into parting with their property. It is now a prosecution or more can ever court or say yenchi Agradaa untum no the state no. After also we show say indeed video where Agradaa ye no or the dada will be ema nipa krono de ne japade eba besi awawa ama nipa krono aboka ekokotia Agradaa aboka nti sisi and na was a prosecution na yes ejuma no. It's otremu or say in the advertisement that appellant herself ran or caused to be run on her own TV station, and they therefore attended the all-night service, where they were subsequently defrauded by the appellant of the sums of money mentioned in the charge sheet. Although it is settled, indeed, tried, that in criminal trials, it is the prosecution that carries the burden of proving the guilt of an accused person, and it must do so beyond reasonable doubt. The burden may shift, especially after the prosecution has established a prima facie case against an accused person. At that stage in the proceedings, the accused will be called upon to open his defense. It is for this reason that it is provided in Section 11(2) of the Evidence Act. Thus, in a criminal action, the burden of producing evidence, when it is on the prosecution as to any fact which is essential to guilt, requires the prosecution to produce sufficient evidence so that on all the evidence, a reasonable mind could find the existence of a fact beyond reasonable doubt. And listen, I'm learning something from what the judge is saying. Judge ne say, baby assembly do you know, a prosecution in afe, a what's a womotre, say indeed Agradaa di bone. Na saa time no mutumi tre say Agradaa di bone a, court no so be ma Agradaa kwan so no so nka nasem. It is our stage in the feno, we to me establish prima facie case etia nipa kro no. And I think say washa chema to me case no, that's where it has got into. This is just by the way. I said the prosecution had led evidence to show that indeed, prior to the 7th December 2022 all-night service, the appellant had run or caused to be run for her on TV adverts showing that on that day at the service, she was going to share some money and was therefore inviting people to attend the said program. See, for example, an answer given by PW4 and reproduced by her own counsel at page 22 of his address to the court. The video, Exhibit B, did not disclose that the accused was collecting monies from the complainants. That is so because the video was an advert made towards the 7th October all-night service. So the video did not include the activities of the all-night service. I said the investigation caution statement of the appellant herself, Exhibit D, left no reasonable mind in doubt to find the existence of the fact that the appellant indeed committed the offense of charlatanic advertisement. Inti judge ne say, o share the course witness statement. Agradaa nankasa ne lawyer no, ensem bi a ogitu mu. Ekan ye efa nsensem ne ho. Eni bibi esi ye bia no. Say subo no, indeed Agradaa ye. Ade na ye say charlatanic advertisement no oyeye. Judge ne nsem a woka no. And so the judge went on. Although I have affirmed that indeed the appellant charlatanically announced on TV that she was going to share some money amongst would-be attendees at the 7th October 2022 all-night service, a critical examination of the particulars of the offense will show that no specific mention is made of an advertisement on TV and even on radio, which will constitute a breach of Section 1371 of the Act 29. And I had to bring the conduct of the appellant under the use of subtle craft, means or device. In order to bring in TV advertisements under the section, it is my humble view that there is definitely a lacuna in the law, apparently because at the time the law was made in 1960, TV and especially social media were not so prevalent. Subsequent changes in the Criminal and Other Offences Act also failed to correct this loophole. Now, Judge Nekrano say, yes, Agradaa with the bonnet there. Now, social Ghana Mrana Krana a Casafasa de no loophole be baby. As a loophole no, Agradaa as an uncle to me issue a dear general. Because Osha Emrana, ye Emrano 1960. Now, 1960 no, not TV ni social media, and theatre to send. It would tie judge and the judgment in the crana. I say Ghana was says I'm running yes, some partner. I say I have found in the law, in order to prevent technically minded individuals from taking undue advantage of this gap in the law, I am appealing to Parliament to take immediate steps to correct this anomaly. It's a judge, you know, Parliament say Parliament and Sessa Sadiena a warm ranimu. Because when they say Yanhini Yan Crawford, it may take advantage of that. Sa side din Agradaa so now can the lawyer person use so would take advantage. Otherwise, like be Ghana for what the nipa kota, not that side of the law, no, as or the general. I say I will now discuss the 2 counts of defrauding by false pretenses. I mean, so the judge went on, to quote, I want the final ruling why he reduced the sentencing, because at this point he's admitting and letting people understand, say, I'm Agradaa Dibone. Now, I say I have closely examined the ROA and I repeat that I was satisfied that at the close of the case for the prosecution was able to establish a prima facie case against the appellants because, contrary to the assertion by counsel for the appellants, the prosecution indeed led sufficient evidence, which evidence was not discredited. So, judge doing some more work in Nana. Or say, indeed, states no evidence that womunye tia Agradaa no nini na trese Agradaa na wedi bone. That's basically what the judge is trying to say. Atiase cases nini na no na judge no ekasa, but you see there will be a branch somewhere, because for the judge to change from a year 15 years to 1 year, no, there will be something, right? There will be something. Now, the above discussions then bring me to the only remaining ground of appeal, which is that the sentence of 15 years imprisonment in hard labor imposed on the appellant is excessive and harsh, taking into account all the circumstances of the case. By this leg of appeal, the appellant is calling on the appellate court to determine whether or not the sentence of 15 years imprisonment in hard labor imposed on her by the trial court on the 2 counts of defrauding by false pretenses, with the sentences to run concurrently, was excessive and harsh in all circumstances of the case. This ground of appeal calls on this court to exercise its discretion to reduce the sentence, if indeed this court comes to the conclusion that the sentence is excessive and harsh. Okay, so it looks like Agradaa lawyers no edin sem echo court. 1. But judge ninin sem ni gune hu ni se nyanse enim. 2. A charge say the boy Agradaa no enye no kware evidence bi ni wa etre. Inti judge no etre say first one now say membo judge nin sem ngu no. Mean to membo judge nin sem ngu, because indeed Agradaa di bone no. Second one I say false pretenses are Agradaa wabon crofo krono no. O hwe judge no and a prosecution need to meet say indeed judge no nsem a work. But Agradaa lawyers asanso katre judge no say the appeals judge say odi yesrew 15 years na dia ma Agradaa na sundodo onti odi say we di bone kra na odi etsomaye nti ene na judge nka so okay ene ne de yenka ho asem that yase because akwa say sebi obi akwa rob wakwa rob ade na ebia ye de na tum 5 years obi koria ebia akokoba no so ye de no koto ebia 10 years yes we ade de now so 10 years na ye de ma no as a too harsh. So basically that was Agradaa and the lawyers no omo appeal part na judge no oba be address it. And I think that was where the judge branched. In imposing the sentence on the appellants, the trial court gave 3 reasons for its decision. First, the court found the appellant's conduct to be reprehensible. Secondly, it also considered that these types of crime is prevalent in our society. And finally, the court also said that the appellant did not show any remorse for the offense. Judge no Emma Agradaa 15 years no. Ojina nyama miensa so. So one Agradaa dia wo ye na nye eye bone kese a wedi. Enyi kwansi ye so ne so. Second, judge na semo a wokan say sa ade we ade bi a Ghana ha say no nkrofo ahase ye sa. Osi wo ye sofo, osi ye we nu obu nipa. Nti e wo say ye de Agradaa case we send a strong message. Third, Agradaa na nkasa no ye de ne ba court a ye ade we no. When show say we nu ne ho. Na still oko radio so a wo ye de obeye onam no okuntokwa. Now, still, just say, when show say we know, and you see, it's because around that time, Agradaa thought, say, case we ain't going to do baby, because ya channel pain, and going to do baby. It's 3 reasons in tia judge no man 15 years, no. I say now, Whereas I totally agree that the conduct of the appellant was reprehensible, given particularly that she leads a Christian congregation as their head pastor stroke evangelist, and also generally that there is a prevalence of this kind of conduct, especially in the body of the Christ, where pastors stroke men stroke women of God sell all sorts of merchandise to unsuspecting and mostly gullible but also vulnerable congregants. However, on the question that the appellant did not show remorse with due deference to the trial circuit court, I cannot agree with this finding of the court below. So say, yes, Agradaa dia oye no entwa ye. Ghana for asha say, but Judge Neka say, Agradaa we nu ne ho a on agree. Dientia. Or say the appellant through her lawyers showed a lot of remorse to the extent that the appellant was even said to have been afraid to even attend the sentencing hearing and that she could not even sleep for days. So since Okas Agradaa nu ho a and the judge no, I know the one kind of quiet. Because you see Agradaa kra the case ni ba no suru so be kokoto no abohu na the lawyer sin so pacho or no Agradaa ne kra no ntumi nda. I say her lawyers then went down on their knees to beg the court to spare the appellant a custodial sentence, pleading that as a mother with young children, a custodial sentence would affect not only the appellant but also her innocent children. So say Agradaa lawyers cry e pacho judge na answer no be ma 15 years no. Agradaa ne lawyers no e pa ne chow e wo court o mo koto ye pa ne chow wo court. Inti say judge ne ba be kasa Agradaa we nu ne ho ana ne team ne show enuhu bia nipa ko na pa chow wo court. Enuhu be na essence a omo akatro say owo mma oma ne ko 15 years a obe say fie. And so it goes on and all of that. I'll say what this sentence means is that the appellant was to spend 1 year in prison for every 100 Ghana cedis she took from two complainants, given that the amount involved was only 1,000 Ghana cedis. Okay, so at this point now, M say judge no, we ohun said that be sentence I dear ma Agradaa na sundodo because sika yes Agradaa we boom growth on the crown sika ne say yes 1,000 cedis. Yes, sika ne 1,000 cedis. Na yes you obi sika 1,000 cedis a sebe o china tun for 15 years there and then adding. So that's what this judge is saying, right? So once again, I reiterate that being an evangelist in whose hands the destiny of several people, her church members, as well as many others, has been entrusted, the appellant was expected to live above reproach, and therefore I condemn her conduct in no uncertain terms. But all factors considered, was the sentence imposed on the appellant excessive and harsh, as being urged upon me by her lawyers? The offense of defrauding by false pretense is regulated by Section 131 of the Criminal and Other Offences Act 1960, Act 29. And at the said section, the offense of defrauding by false pretenses is described as a second-degree felony, and it is generally tried summarily. The section does not provide any minimum punishment for the offense of defrauding by false pretense. It may, however, attract a sentence from a fine to a maximum of 25 years imprisonment or both, or a fine as well as a term of imprisonment. Thus, judges in Ghana have been given a wide room to exercise their discretion when it comes to the imposition of sentences on people who have been convicted for fraud under this section. Into say what Ghana mrana, sa fraud, defrauding by false pretenses no. Say yeah the case no ekoko di court and no na judge ni decide because mrana ma judge ne say obetumi ama say ebia wo be ma osika say tua. The bakone esi we defrauding no judge no. So good time mu ni e chill say we defraud you obetumi aka say ko tie sika na sika no mani pakro no and judge betumi ama up to 25 from 1 year to 25. Nti enene de e judges no etumi eno mo de yesa. Nti judge say ni bu efudi a obetumi ama akwa kodem 25. Meanwhile na bia boni a we di na nsheda na the case yesa. So it goes on into say in imposing a sentence on a convict per the Ghana sentencing guidelines, which the court below correctly invoked, some of the factors a court takes into consideration are the age of the convict, the amount and number of victims involved, the manner in which the crime was committed, the prevalence of the offense, whether there has been a restitution order, whether or not the convict showed remorse, and whether or not the convict is known. So since almost sentence here, judges no, omu yusu a year documents bia, your friend a year the Ghana sentencing guidelines. No sentencing no, ejina nipa krono ni age eso. Ejina nipa krono ebia nkrofo a webu eso. Ejina senia wodi saa krono o saa bone no. Bro bone na nipa kono ye no otai ye. Ati ase nipa kono nu ne ho. So say in the and so the judge goes on, very typical, to give us some of the cases and all that. So say it was after he had made this profound statement of the law quoted supra that a punishment must fit the crime as well as the convict. And after considering that the sum involved, okay, this is a different case. So basically, we now understand why the judge did what he did. At this point, already, now, it makes sense to us. The judge who is Agradaa di bone, and so who is be 15 years I dem Agradaa in try, right? Let me read the judge in the final statement. The final statement was said, I say, after quoting extensively from Holy Bible, I may sound paradoxical in saying that there would be no attempt to mix religion and justice delivery. I'm not saying that religion does not have a place in judicial adjudication and justice delivery, because after all, we still swear on both the Holy Bible and Quran, and we also affirm in the courts. But my caution has to do with the penchant to prophetically predict the outcome of pending court cases, because such prophecies are not fair to both the parties and the court itself. To say, judge ne some work and say, "Ma so for bi am sorry nka say me na me share nkom say Agradaa ye be yi no ne za anya." Em say judge no, the judge was worried about that. The judge ne some work and say, "I affirm that appellant sentence of 25 penalty units on count 1, or in default of her payment of the fine, of this fine, the appellant is to serve an additional." Okay, meba. Let's go. Into judge in some more kind of. I say in conclusion, in the light of the foregoing, and having taken the following matters into consideration, that the victims of the offense for which the appellant was convicted and sentenced to 15 years were only 2 in number, and amount involved was also 1,000 Ghana cedis. Into I say Agradaa and Crofona will bu omo no mo yemienu. Sika will bu omo so no 1,000 cedis. I said that the appellant has been ordered to refund the amount involved. That is 1,000 cedis to victims of her crime. Inti Agradaa yakatre say 1,000 cedis no. One fan man Crawford back. That there is no defined minimum sentence of imprisonment imposed by law for this particular offense. As I told you earlier on, that offense we know eyana yema minimum sentence. I said that the trial circuit court failed and or refused to make the 32 days the appellant had already spent in custody count. That, in the opinion of the trial judge, the sentence of 15 years in prison in hard labor was meant to serve as a deterrent, a view I subscribe to. I hereby reduce the sentence to 15 years imprisonment in hard labor imposed on the appellant by the trial court, and rather sentence the appellant in the following manner. It was indeed the only reason a judge say Woma Agradaa 15 years. One of the major reasons they say or per se adiewe a serve as deterrent. Na bronika se bibi serve as deterrent. Say obi behwe so. Na we hu ne say eh de Agradaa ni o ntimi so ma me nkonko di sa aboni ni bi. Ono judge no say wo fo aso. Na so 15 years ne de esondodo. Into what so. Inti eni I affirm the appellant sentence of 25 penalty units on count 1, or in default of her payment of this fine, the appellant is to serve an additional term of 3 months imprisonment in hard labor imposed on the appellant by the courts below. Also, the appellant is further sentenced to 12 calendar months imprisonment in hard labor on count 2 and 3 from the date conviction, that is the 3rd of July 2025. The appellant is further sentenced to a fine of 200 penalty units on counts 2 and 3. In default of a payment of fine, she is to serve an additional term of 1 year imprisonment in hard labor. All the sentences mentioned in paragraph A, B, C, supra are to run concurrently and with retrospective effect from the date of her conviction and sentence. That is from 5th July. Into tie judge in some work wamema fines bi ne nyama, but basically no Agradaa yes 12 calendar months on them. E share here from time I chin it to July, August, September, October, November. Into Agradaa by July no e was here releasing no. What you say? Into Agradaa you be releasing no exactly on 3rd July. From the judgment, make an name date be releasing, but from the judgment, that's what the judge is saying, right? Agradaa should be released until by July. Agradaa be fear. Until Agradaa 5 months. This is the court document. I wish you for. Muntra your comment box nimo. But that's it.